Jackie Tran is the first one I'm going to speak of. Permanent resident, in his late teens, involved in crime in Calgary, first conviction at 19 for cocaine trafficking in 2001. CBSA tried to deport him for 6 years, but despite having a long criminal record as a gangster and a major drug trafficker, he never received a single sentence of more than 2 years less a day. And therein lies the problem. So I just have to ask you whether you think that Jackie Tran was a serious criminal. That's the first question.
Well, I don't know about his particular circumstances, but it sounds like
You're a criminal lawyer? Or
I'm an immigration lawyer, not a criminal lawyer.
And you've never heard of Jackie Tran? I'm surprised.
No, I don't know his particular circumstances. So, I mean,
these people aren't infamous throughout the country.
You know, and also, I hate to tell you, we don't want to be adversarial with you. We're just trying to give you the other side of the story. I know that you have your sound bites. You do the crime, you do the time.
Actually,
people are individuals.
That's not my personal sound bite.
Okay. But I'm going to give you...
Well, stop the clock. Ms. Sims, everybody take a deep breath. We're getting a tad adversarial between the witness and you, Ms. James.
Yeah, sorry, I just asked a simple question, and
well,
they didn't know who Jackie Tran was, so I was surprised.
Again.
I just said I didn't know the circumstances.
Let both of you, please.
Right.
Thank you. We'll start the clock.
That's fine. I'll give another example. Another person lost control of a vehicle and killed a pedestrian while street racing. I'm not going to mention the name because you probably won't know this person either. He was given a conditional sentence of 2 years less a day, ordered deported from Canada in April 2003, but still not deported until April 2009. 7 years to deport due to multiple levels of immigration appeals. So this is the point that we're trying to address. These people do not belong in Canada. They've committed serious crimes. And I just have to, I listened intently to your speech, and I have to say I was actually very alarmed that you believe that fraud, impersonation, and theft under $5,000 is a minor sentence, as you put it. And the reason I say this is I actually have another example here. Joselita Arganda, who came to Canada from the Philippines in 1995, and I bring this to your attention because you mentioned specifically fraud and theft. This person was sentenced to 2 years in prison in 2007 for a wide variety of crimes, among them forgery, credit card fraud, possession of counterfeit money, and possession of goods obtained by crime. Reoffended after leaving prison and sentenced again in 2009 for possession of property obtained by crime and for failing to comply with court orders. The following year, he was sentenced for possession of a weapon. So the reason I'm alarmed is you think that fraud and theft under $5,000 is a minor offense. And then in the same conversation this first hour, you've indicated that you're very concerned that some of these people that may be deported may be the sole supporter of their family. And I'm thinking of this particular person. If he was the sole supporter of his family, then it was through fraud, theft, impersonation, forgery, and so on. So I just have to put that on the table because I was very alarmed. But I'm going to ask this question. In the opening statement, you talked about C-43, and the major problem that you have is that you're taking away the appeal rights of permanent residents. So I just have to ask this question. Do you think it's too much to ask permanent residents to not commit serious crimes here in Canada?
Can I respond?
Sorry, to that question, please, if you could respond to the last question.
The question begs the, I guess the response is what we've been talking about for the past 45 minutes, I think, is addressing that issue. So I don't know if it's obviously hasn't gotten through to what we're speaking to. With respect to, there's many factors, and again, and I'm not saying people should be allowed to stay in Canada, but we're saying they should have a right of review. And I'm sure if it was somebody that was your relative who was a permanent resident of Canada, or your constituent that was a permanent resident, and it impacted them so deeply, well, I'm not saying they should be able to say, I'm not the decision maker. I'm not saying those offenses aren't serious. I'm not a criminal court judge. Don't get me wrong. What I'm saying is someone independently should have a right of review. And with respect to these long delays, as we said, we don't believe in the long delays. Those people should be detained. If they're serious and there's extensive criminality, lock them up. I don't have a problem with that. But with respect to whether I think fraud is a serious offense, I didn't talk about somebody who committed offense after offense. I talked about someone who used false identification to get into a bar. Okay. Now, I think you can go onto any university campus and you'll find a whole bunch of people like that.
Do you really think
Ms.
false?
James,
sorry, I just have to stop. Do you really think that false identification in a bar is a serious offense? That certainly wouldn't warrant a 6-month
Ms.
offense.
James,
so I find that a little.
I have order, please? Ms. Seligman was very patient, If you could let her finish her answer to your question.
Yeah, I was actually.
Point of order, Chair.
Thank you. I was
Point of
actually,
order.
thank you,
Stop the
Chair.
clock.
I was actually going to say, actually using a, oh, I'm sorry.
We have a point of order. We have to stop and listen to that next.
You know, Chair, we invite guests, witnesses to come here, both sides do. I think it really behooves us that once we've asked a question, that the witness be given time to respond in a respectful manner.
Thank you.
Thank you, Ms. Seligman.
I was going to continue. Actually, using a false or fraudulent document is offense under Section 368 of the Criminal Code, carrying a maximum potential penalty of 10 years. A 20-year-old permanent resident who is convicted of using fake identification to get into a bar while visiting the United States is inadmissible under IRPA for a foreign conviction. Even if they got no penalty or a $200 fine, they would be inadmissible to Canada, no matter if they spent their whole life in Canada. It is a criminal offense.
When we talk about immigration, obviously Canada is one of the most welcoming countries, and actually we have the highest immigration levels in the last number of years. But I would have to think that if we're going to admit people into Canada, we want them to succeed. So the example that you gave, although it's talking about someone going into a bar underage with a false identification, I would have to say that if we're going to pick and choose the people that come into Canada, I think I would certainly want to pick and choose the people that are most law-abiding. So although you've given that example, I think it's a pretty weak example. But again, if I'm going to choose one person over another, I would always tend to pick the person who's always law-abiding. And I think that's what most Canadians would expect with regards to our immigration system.
We're in
But I
agreement
just
on
have,
that.
Thank you.
Not in the whole
We
thing.
have a minute, Ms. James.
Thank you.